So I'll just wait for you, Jenny. I'm all good.
Yes. Yep. So good morning, everybody who's currently online. We're just going to just wait for 2 more minutes until we can get all of our other delegates online for this webinar, and we do apologise for the technical glitches. So we're just going to pop this webinar on hold just for 1 second. Right. Hi again, Thomas. We have a few people online now. Now, my apologies to all of our members who have registered for today's webinar. We did have a technical hitch, and we've managed to sort that out. So please accept our apologies for this, and to you, Thomas, for having to restart your presentation. So for everybody who's online, we have quite a few people online now. Welcome to this Property Law Tools in webinar, which has been presented by Thomas Gibbons of McCaw-Lewis. So I'll now hand over to you, Thomas.
Thanks, Jenny. Kia ora koutou. Welcome, everyone. Apologies if you couldn't hear before, and probably apologies also if you could hear before and you have to hear some of the same material again. But that's how it goes, I guess. Can't always control the technology. So I'm going to dive right in. This is more or less a follow-up from the easements and covenants webinar that I ran in March, more focused on property law tools. In particular, there is definitely some overlap, but entirely different material, basically. I want to focus on practical issues, and I've used the opportunity of some of the questions arising out of the last webinar to bring forward those as case examples as well. So a little bit about me. I'm a director at McCaw-Lewis. That's my day job. I do a lot of property work. I head up the property team there. Property is a very amorphous, broad phrase, covers subdivisions, obviously, do a lot of technical easement and covenant advice for local authorities, landowners and others, do a lot of unit title work. That's probably my number one specialty in some ways, and some of that's subdivision title based, some of that's agreement or governance based, and also do a lot of work on RMA and LGA issues to do with district plans, plan changes, consent interpretation, some work for local authorities, as I said. So hugely varied, makes every day different. And when I'm not doing my day job, I'm busy being a board member for Survey and Spatial New Zealand. So I've been involved for a few years, and some of you may have met me through that. Right, bit of an outline. I'm going to hop around a bit, and this is an effort to impose some structure on that. Going to talk about agreements, resource consent, some practical issues, role of surveyors and lawyers in working together, some process issues, and then a bit of a mix of other things that come up. As I said, I talked about some more of the statutory tools and easements and covenants last time, so a bit of a different take on things today. Important part of this first part of the presentation is to remember as surveyors and other advisors, spatial professionals, that there's this thing called an agreement for sale and purchase, and it's in place because the developer wants to sell. They want to create lots when they're subdividing and then sell those and make money out of it. And really important to keep that agreement front of mind, because it's right at the end of the process, and subdivision is really a preface to getting those sales in place. And because most sales of subdivided sections occur off the plans, I wanted to talk about some of the common provisions that end up in those, particularly those that touch on the work of surveyors. So some of these common provisions are things like restrictions on changes in lot size. So it's not uncommon to have an agreement for a sale of a section off the plans, which perhaps suggests a lot will be 400 square metres based on a scheme plan, and then has some ability to vary that, you'd hope, because the lot on the LT plan doesn't always end up exactly that. So sometimes we have a 2% allowable variation, sometimes we have a 5% allowable variation, sometimes more. Sometimes we say that if there's a 2 to 5% variation, then the price will change on a pro rata basis. That's important for the developer. And sometimes there's a right for a purchaser to cancel if the lot isn't substantially the same size, if it's very different. So the implication of that is that as surveyors, you need to keep the lawyer informed about changes in between the time of the scheme plan and the LT plan. And ideally, you want to get a sense of how accurate the scheme plan is going into the agreement and what level of tolerance you think is going to be acceptable for the lawyer to put in the contract. Important to be aware that most agreements for sale and purchase are done on what's called an ADLS form, Auckland District Law Society and Real Estate Institute, and it's a standard term in that when you're selling vacant land in a bare section, that it's pegged and the survey pegs are identifiable. So again, you don't want to get to the settlement date as a lawyer and find that the survey pegs are not visible, not present. So very important for surveyor and the lawyer to be talking to each other to make sure those are in place. Common if it's a sale off the plans at a very early stage to have a condition around approval of resource consent terms. So some off the plan sales are done when a resource consent is in place, some are done before then. And if they're done before then, if contracts are signed up at that very early stage, then it's absolutely critical that the developer has the right to approve the resource consent before they decide whether they're going to go ahead. They might want to change terms, they may in some cases want to appeal. So they've got to be happy with that consent. Occasionally, a purchaser also has a right to approve the resource consent. That becomes more problematic because it provides an avenue for different purchasers to raise different issues. So it's not something we advise, but sometimes it does end up in the contract. So keep in mind the lawyer and the developer are going to need to understand how the resource consent fits into the contract. And pre-sale percentages are one of those other provisions that ends up in agreements. So sometimes the developer must sell 60% of lots before they're committed to sell all of them in the development, or even before they're committed to go ahead with the development. Those kind of provisions end up in contracts a lot. Sunset dates are absolutely critical to be aware of. And not only do we have surveyor and lawyer involved in these, we often have real estate agent as well. I've seen situations where the real estate agent will say quite confidently that titles will be through by February. And the lawyer, being a bit more conservative, will often add a bit of time to that and say, well, maybe we'll put a sunset date in the contract of May or June to provide some leeway. And unless the surveyor has some really good involvement in that and is able to step up and say, well, actually, there's no way titles are going to be through before September, you're going to have a problem. It's really important to match the sunset date up, not to what the agent or even the developer expects, but to when the surveyor actually expects to get titles. And they always take longer than people think they will to get. Not only do we have sunset date conditions in contracts, we also have an implied condition in section 225 of the RMA. Two key implications of this. One is that the agreement is effectively conditional up until when the plan deposits. And that means that the developer cannot get the deposit released into their own bank account until the plan is deposited and in place. Up until that time, it's held by a stakeholder. So they're really, really hanging out to get those deposits and then the sale monies. The other thing about 225 is that it imposes a requirement for a developer to make reasonable progress over a period of time with their subdivision. And this is a very vague legal phrase, quite a difficult one at times. I sometimes wonder whether reasonable progress is taking a whole lot of little steps, sort of one a week, or whether it's taking a whole lot of big steps, 2 or 3 every 3 months. And the legislation isn't really clear, but what's important is that someone is making effectively continual progress to show that it's been reasonable. If they don't, then there's a chance the purchaser will be able to cancel the contract, which is obviously absolutely disastrous for a developer most of the time. So keep in mind that implied condition is in place and there is a need to keep pushing things along, and there's no real ability to contract out of that. Important to keep in mind the impact of COVID-19 delays in this environment. I've been lucky enough to work from home pretty much all the way through lockdown, but not everyone has. Not all works that should take place have been able to carry on. And this is going to have an impact on sunset dates and contracts. Titles we thought would be through by May might not now be through till July, and that may allow a purchaser a right to cancel. And I'm certainly seeing some other developers and lawyers with their backs up against the wall hitting very tight timeframes on sunset dates because of this issue of COVID-19. Lawyers are also dusting off contracts for what are called force majeure clauses. So these are clauses that say things like international events like war, sometimes economic events, acts of God, tsunami, and so on. If they impact on development, then the contract can be suspended or delayed or sometimes cancelled. Many of those clauses also refer to pandemics and are now coming into effect, where developers are sometimes able to say, well, I don't have to have made the same progress I would have because of these issues. Sometimes they work for purchasers as well. So really important to be thinking about whether there's any dramatic event clause in the contract which will allow delay or sometimes cancellation. And interestingly, section 225 talks about reasonable progress, and it's reasonable not to make any progress at all during a lockdown scenario. But section 224 of the RMA, on the other hand, doesn't have that same element of reasonableness. It seems to be quite a hard and fast time frame around where you get to on compliance with resource consent and work sign-off. So some developers, again, are going to hit the wall on tight timeframes because of those strict dates. And really important for surveyors as part of the development team, actually a critical part of the development team, to be talking to lawyers and their clients about these things. I want to make a point about resource consents and the number one point to make is they're in fact essential reading for the lawyer. It's often surveyors and planners who are involved in applying for the resource consent. and dealing with the conditions, and in fact making sure all the conditions are being carried out. But the lawyer really needs to read this as well at a very early stage. It's in some ways unfortunate that it's only occasionally I get to read the application and what the applicant is thinking about what kinds of conditions should be in place. But some of the recent conditions that have really caused some grief are things like this. So where an easement surrender is required under a resource consent condition, and that involves a third party signing off on that. It's almost inevitably the neighbour or someone like that. And that consent can be freely given or not. The resource consent may absolutely require that this be done, but there's no way to guarantee as a lawyer that the neighbour's going to sign off on giving up an easement. So those kind of things require early engagement if they're going to be part of the application, let alone the consent requirements. Another one that's creeping in is a requirement for a private developer agreement. And so if you've got a consent condition that says a private developer agreement must be entered into, perhaps because the developer is providing some private infrastructure or upsizing for the benefit of the local authority, there's going to be some problems ahead. There's going to be some delays ahead. Because while these conditions make sense in terms of getting cooperation with the council, you've got to remember that a private developer agreement is effectively a commercial contract between the developer and the council. It's going to be negotiated. If the council's lawyer is bullish, there's going to be difficult terms that a developer won't want to comply with. There's going to be issues about the developer's lawyer trying to soften those terms, which we often do. And so this can hold up progress a lot. And if it's a strict condition that this be granted without any idea of what the terms are going to be at the outset, then it's a recipe for things getting held up. One of the other consent conditions we saw recently that caused some issues was we've got a big area of common area, not in a unit title context, and you're wondering how to manage that. And because councils are more astute to governance of these types of areas, they might say, well, why not a management company to look after this recreation lot? And sometimes the condition will be so strict that it requires a company rather than, say, an incorporated society. And this becomes very important from a legal compliance point of view later on, because some types of common facilities get tied into the Financial Markets Conduct Act sometimes. And then we've got to go through a whole lot of extra process around that. So broad-based consent conditions are very useful that say management company or society or other entity. And again, there should definitely be a discussion with the lawyer at the start of the process about why this is needed, why it's a good idea. It's not a good idea just because council says it is. It's got to be workable in practice going forward, both for sales and for the ongoing success of the development. So those are just some of the types of examples that come up. And again, what I want to emphasise that it's really important for the lawyer to be involved in reading the resource consent at the earliest possible stage, sometimes even at application stage, definitely once it's issued. Some of the other resource consent conditions we see come up, resource consent issues we see come up, are where the consent envisages a staged subdivision and what's actually done on the ground then doesn't match that up. So again, you want to keep enough flexibility in that you don't have to go seeking a variation at a late stage. And it could be the developer is looking at an issue like not wanting to pay DCs for a particular lot, development contributions on a particular lot at a particular time, not wanting to remove fill from a particular lot at a particular time, just wanting to do things in a slightly different stage process. And important to keep that flexibility in there so that the developer can do that without causing grief later on. And consent notices, be aware that these obviously arise from consent conditions to be complied with on an ongoing basis, but the lawyer may not see the actual consent notice until a very late stage, sometimes not even really until the plan's ready to be deposited. So again, important to keep the lawyer in the loop about where those are up to, what those consent conditions are looking like, and what the consent notice is in fact looking like, because sometimes they do end up with adverse or terms that are actually very difficult to apply or enforce in practice. I want to move on from resource consents to some practical issues that come up. Number one is around utility company easements. And look, in Hamilton, there are things like well electricity easements, in other areas, chorus easements, and so on. Some are still using encumbrances. But really important to be aware that while they have standard terms, 95% of the time they are still negotiable. And it's not uncommon for these utility providers to approach surveyors or lawyers or planners or other involved, surveyors or planners or the client themselves directly, and get them signed up to an easement agreement, which later binds the landowner to easement terms without any room to move. So getting the lawyer involved at an early stage potentially allows some negotiation to take place. And some of the things that we look at are whether facilities must be underground. That's quite important sometimes for things like power, not necessarily for all kinds of power easement facilities, but can be very useful. Allocation of costs. Is the utility provider going to pay all the costs for registration, survey, and so on at the end of the day, or is that going to fall on the landowner? What happens if facilities are decommissioned later? Should the easement be able to be removed, or is it going to exist forever? And that forever part of electricity easements can be quite a challenging issue at times. Other improvements. So it's often the case that these kind of easements will say they require exclusivity over the easement area and nothing to be built there, sometimes no trees or shrubs to be planted, sometimes nothing at all, and effectively it becomes dead and unusable land. And sometimes those things are negotiable because there's no reason why you couldn't have an electricity easement in one place and a fibre easement in the same place without the two affecting each other too much. So those kind of issues around exclusivity and other improvements are very important, and certainly lawyers like to get involved in those, but can only get involved if they know about them. Now, I've put that picture up, and it may or may not show up well on your screens, but it's designed to highlight an issue around jointly owned access lots. I'm just going to pause on it for a minute because it is quite an interesting survey plan in some ways. We've got at the lower right-hand corner, I hope it's your lower right as well, some attached apartments, which therefore look to have, one would hope, party walls in between them. We've got a couple of other ones just above them which are attached. Then we've got some others which look to have effectively zero lot boundaries in place, and we're often putting in easements in place for maintenance on those zero lot boundaries. There's quite a few different aspects there, but really what I wanted to talk about mainly was this jointly owned access lot in the middle, and keeping in mind this is not a unit title development. Let's say it's a fee simple development. So Section 298 of the Property Law Act applies to jointly owned access lots such as this, and there's some detailed provisions there. If it includes a driveway, if it's a jointly owned access lot with a driveway, there is implied a right to pass and repass, and kind of similar to an easement. But I also like to put a proper easement in place as well, a registered right-of-way easement. And there's two reasons for that. One of them is to provide more certainty as to the easement terms, because I'm not always entirely happy with the implied terms. The other thing to keep in mind is that if there are other services, they're not necessarily going to be covered by Section 298. And probably those other services are going to come over that jointly owned access lot. So a good idea to put an easement in place as well. Not a hard and fast rule, it's not something I always invariably do, but it is generally recommended that there's an easement in place over that jointly owned access lot, notwithstanding Section 298 of the Property Law Act. Another practical issue is development contributions, and this is very dear to my heart coming from Hamilton, because some of the stats have shown that Hamilton is at times a bit of an outlier around development contributions, but probably something that applies in nearly every local authority. And what we're seeing is issues around timing. Again, a lot of these have been payable traditionally at the time of 224C, but councils in fact have more flexibility than that under the Local Government Act, and some of them are pushing them out to service connection or building consent stage. Sometimes that's good for developers because it puts more onus on purchasers. Whoever's building the house later on suddenly has to meet a share of the DCs. Although, on the other hand, I've often seen political pushback about these things. Someone's building a house and suddenly has to pay an extra $7,000 or so at the time they put in a service connection or get a building consent. That can cause some issues for purchasers, and those are the kind of calls that end up on councillors' tables sometimes. But be aware of these timing differentials, because sometimes councils have discretion over them, and be aware that often you can manage timing issues with consent notices. So suppose you're developing a lot as part of a subdivision and you planned that it would have all the service connections and be ready to build on, but for whatever reason there's a timing issue and you want to leave that as undeveloped land. I've certainly seen issues where developers have been able to arrange with council to put a consent notice on the title which says this lot will not be sold until it's developed and DCs are paid, or this lot cannot be built on until DCs are paid. And that provides a tag on the title, which means a purchaser is going to be very worried about it and gives council some comfort that DCs are going to be paid at a later point in time. So those timing issues can be managed in some ways. Also be aware that of the way that tools can be used. So I talked about easements and covenants in a lot of detail in the last webinar. Be aware, of course, creating an easement requires a survey plan, and if for whatever reason that can't be done at a particular time or the location of the easement is uncertain, then you can have, as I talked about with utility arrangements, an easement agreement in place. And if you want to make sure that runs with the land, if someone sells their land, then you can in fact have a land covenant which requires someone to later on enter into a legal easement, with the covenant then dropping off the title if it's worded properly. So property law tools can be used in that way. A covenant that runs with the land can be used to enable an easement later on that will also run with the land and make sure the right people are agreeing to the right obligations at the right time. Another practical issue I see coming up a lot is around unit title boundaries. And as I've said, do a lot of unit title work, love them to bits. And one of the issues I do sometimes see on survey plans, particularly older ones, is a lack of definition around exact, precise boundaries. And I'm aware that the old survey rules used to provide for the basic position being the boundary was the midline of the wall. And this has caused enormous grief in some cases where that hasn't been the case, because under the old Unit Titles Act, the starting point was that the body corporate would look after common property and individual owners would look after unit property. So where you had a survey plan saying the exterior of the building, like the wall here, was individual unit property bit by bit, you had quite a lot of problems working out how the allocation of maintenance would work, and common property was often the easier answer. But I want you to go a bit more detailed than that. We've got a new Unit Titles Act, we've got new cadastral rules that are not the old ones anymore. But it's really important to think about a high level of detail around labels on the unit plan. This is one that has some greater level of detail, in fact has a little edge of common property outside unity areas, but I've had arguments about, imagine walking into an apartment building and all the doors are grey and then one of the doors is painted black, and that can cause a concern for some body corporates. They want everyone to have the same colour door, and so then we come back to questions around whether the external face of the door of an apartment is in fact common property or unit property, and that can come back to the exact survey boundaries that are in place. So sometimes it's not enough even to show walls clearly. You need to think about all the things related to those, window opening areas, doors that are inset from the wall. All those kinds of levels of detail are important. My general view is that building exteriors are always better off as common property, because that makes it simpler later on to determine who's responsible for maintenance. It makes it a very easy question. Sometimes people do want to work around that deliberately, and I understand that, but the starting point of external boundaries being common property does make things a lot easier. But what I really want to get across here is the importance of that level of detail about exactly what facilities are where, exactly where those boundaries sit, so it's very clear to someone picking up the plan later on. Which leads on to another topic about the roles and responsibilities of surveyors and lawyers and the importance of communication. And look, these are slightly flippant diagrams in some ways. Well aware that not all surveyors are out with theodolites anymore, despite what the media would sometimes have one believe. I've also put up the picture on the right because this is your fairly standard project management type chart, and it is absolutely inconceivable or ununderstandable to the average lawyer who just doesn't think in that way. So keep in mind there's these assumptions about what people do, which can be wrong. Obviously, a lot of surveyors are heavily involved in project management. Lawyers are not necessarily project managers and don't approach problems in the same way. And one of the most valuable things I think a surveyor can do is impose project management on the lawyer, impose project management disciplines on the lawyer, so that they are working to the surveyor's time frame, not their own, effectively. And to highlight some of these issues, picture on the right, lawyers will often be looking at a scheme plan or an LT plan without any idea of the land contour. They won't understand why access is here but not there, and it could be because it's all a big hill and you need a safe driveway access. That won't necessarily be completely understandable from the plan, which highlights the need for really good communication between people around that. I've put up a form of easement or land covenant, and that's on the left-hand side, and that's like an old form, but we still use documents that look a little bit like that. And keep in mind that while we have implied terms in Property Law Act and land transfer regulations for easements and things like that, really important to get the lawyer involved in the level of detail around those. And absolutely, even with land covenants, a lot of them are drafted by real estate agents, but lawyers have to translate those into more binding legal documents sometimes. And of course, lawyers have their own role in e-dealing and getting that coordinated with the surveyor, particularly around fast-track processes. I put up this diagram because I think it's still on the LINS website around how lawyers and surveyors and LINS and others work together. And part of the message that came through when this diagram was done is that lawyers are involved in every step of the process and best to manage it. And the reason I put it up is to disagree with that point. I think fundamentally surveyors are the best to manage this whole process. They understand all parts of it. They're involved in all parts of it except perhaps the sale. They understand the consent conditions better. They understand the works on the ground better. They understand the survey plan better. Lawyers certainly understand the agreement and the legal documents better. But as long as we can get the two talking to each other, seems a good idea for surveyors to really run this process because they're so involved in so many parts of it. And look, I shrugged because number one question to ask yourself sometimes, does the lawyer know that a subdivision is happening? Don't assume anything. And the number of times gets less and less as I get older, but number of times we've been told, hey, it's all ready to go. Here is your 223 and 224C titles next week. And the answer is no. Because there's actually quite a lot for a lawyer to do, and that kind of, hey, here is your 223, 224C assumes that the lawyer hasn't been involved in looking at the head title at an early stage, which they should. They haven't been involved in reviewing the resource consent, which they should. They haven't been involved in looking at easements and covenants in an earlier time, which they should. And really important to have that early level of communication about things. The lawyer should be involved in things like reviewing the resource consent and the plan. They're likely going to have to prepare some documents like easements and covenants. Absolutely, they'll have to go away and most of the time get mortgagee consent to what is being done. And that could take 2 days, that could take 5 days, that could take 5 weeks in one recent example. And no developer wants to be waiting 5 weeks because the lawyer only just found out and now needs to go to the mortgagee. They're involved in getting documents signed by the owner and, of course, in the e-dealing process. So lawyers, there can be a temptation to see their role as falling right at the end of the process, but they dip in and out of that process ideally. They're involved in early stage with head titles, they're involved in early stage with consent conditions, and they're involved at a medium stage with getting things prepared, as well as at the end stage of lodging the subdivision and creating the titles. And then they will be involved in the further stage of selling down. So I've emphasised that point around the timing of mortgagee consent because that's one that can often trip us up a lot, and highlighting that point about settlement, because once the job of creating the new titles is all done, there's this further job of actually getting the sales done, often under quite significant time pressures, because by then the developer is really, really keen for the money, and that has to be factored into how the process is managed. A couple of other issues around boundaries, and look, I used to walk along outside shops and so on and not really think about them very much, and not really think about the awning overhead, which is sort of part of the shop but is above the footpath, and didn't really have a huge course to think about it until this Chang decision came through a few years ago. So we have a building there, I'm going to call it Levington's, and let's say the unit boundary is the outside wall, and then we have this awning poking out from the wall over the footpath. Well, who owns the awning? Is it part of the local authority's property? Is it body corporate property? Is it owner's property? And the Chang decision went through various iterations, as complex issues do, and the court decided the balcony / awning in that case was actually a fixture, and ended up going through various further machinations around who should pay, who should repair it, body corporate, who should pay for that, some owners, and so on. No one really expected that as a lawyer, I don't think. Certainly wasn't my instinct that it would be a fixture. I thought maybe incidental rights. But again, if that had been noted on the survey plan or understood as part of the boundary of the property, that might have been a useful way to approach it. I think because it's strictly outside the boundary, it couldn't easily be incorporated into the units, but important to keep in mind we need some mechanism for dealing legally with what this is and who's going to pay to look after it. Another issue that's coming through is around mixed-use developments. So it's really important to be aware that the Unit Titles Act is absolutely strict around how levies are set. You have this thing called utility interest, which is the equivalent to the old unit entitlement, and usually set based on ownership interest by a valuer. And once you've got that in place, it's possible to change it, very difficult. But the important point is that levying has to be set absolutely strictly based on that. There's no ability to get around that. You can't have an equal cost per unit or a fixed amount. You can't really cater for different uses unless they're recorded in the valuer certificate. So where you have mixed use developments, in particular with some commercial on the ground floor generating much more rubbish than apartments on the upper floors, which are only used irregularly, the levy formula isn't that flexible in providing for those. And I'd like to see this become a lot more flexible, but it doesn't look to be on the horizon. And there's quite a few cases now where people have tried to set levies differently for different uses, and have come asunder essentially, and found that those were challenged later. So important for the surveyor in their role to be thinking about what will the use be, mixed use or whatever, how are we going to allocate different values, if we need to try to allocate different costs in another way, how are we going to try to do that, what legal mechanisms might be able to be used for that in terms of, say, land covenants or something like that. Also important to keep in mind security issues with mixed-use developments and rules applying to different uses. And there's been a lot of uncertainty in New Zealand about whether rules, body corporate operational rules, can actually regulate or restrict uses, and such as short stays or commercial use or whatever. There's a bit of sign that rules can these days, but sometimes the safer option will be a land covenant. I wanted to touch on section 339 of the Property Law Act, another one of those property law tools. So this allows a co-owner to apply to the court for the division of land, or for the sale of the land, or for one party to buy out the other. There is provision in the Property Law Act that this cannot contradict subdivision rules in the district plan, but there's a couple of important examples here I wanted to briefly talk through. One of them is the Lake Hayes case, where one person owned one unit out of 9, and a financier who'd taken over from a failed developer owned the other 8. And the financier who owned the 8 was obviously trying to negotiate over a period of time to buy number 9, so they'd have the whole property and could redevelop it. And when they found that the owner was being a holdout, eventually they went to court. And they went to court to do 2 things. First of all, to cancel the unit plan on the basis the body corporate wasn't functional, which it wasn't. It had no meetings, it wasn't doing maintenance, but that's not unlike many other bodies corporate I know. And then they sought a second order under the Property Law Act for buyout, so saying this one owner must sell the unit to the other owner who owns the 8. And the court did in fact order that. The court said, we will require this person who had a unit yesterday to now sell their share in fee simple to the other co-owner. And one day this person owned a unit, the next day they did not. And the financier was now a developer again because they had the whole property. So that was done under a 339 application. A very powerful tool in some instances. Mackenzie and Smythe is a case under 339, which is also important because there's been a lot of issues and drama around cross-lease conversions. And this was an issue where one owner wanted to convert the cross-lease into 2 fee simple properties. And the other owner didn't initially want that. It went to court. The court said under a summary judgment process, which is easier than a normal court process, that no, we will in fact order this. We will order this division so that you can each have a separate fee simple property. That won't always be granted. It depends a bit on the facts, depends on the planning rules. But in light of the Environment Court's decision a while ago that conversion of cross-lease to fee simple is still a subdivision, bear in mind that section 339 of the Property Law Act provides another way around that if you're absolutely stymied with an owner. Of course, conversion by agreement's always the easier option. A few comments on covenants, really to highlight some issues happening in the Environment Court. In the Criffle Deer case is important. It was about protecting visual amenity outside an urban area. And the court spent some time debating whether a consent notice was better than a private covenant and how long the covenant should last for. Now, as a rule of thumb, I don't like land covenants that last longer than 30 years because I think that's long enough. That's roughly a generation of environmental thinking or something like that. But the court emphasised that a land covenant could last forever here, and it was in fact in the court's view more secure than a consent notice where someone could just go to council and get that consent notice removed. So in perpetuity, yes, it is a very long time, but it shows the court in that case being really unsure in some ways which way to go in terms of consent notice versus covenant. Albert Road was another case about development outside the normal rural-urban boundary in Auckland, and a landowner wanted to subdivide one property into 2 and was suggesting they would put a restriction on the balance land to say that that couldn't be further developed until the planning framework changed. And there was talk of putting a development agreement and linking that to the title, perhaps through a land covenant or encumbrance. But in that case, the court said, no, we prefer a consent notice. We think this further subdivision is something council wants to regulate. Council is best placed under a consent notice, which is an instrument under the RMA, than some other kind of development agreement or something like that. And Ahuarika Trustees is a case about a side agreement, essentially a developer saying they would put money into environmental restoration through an iwi group. And the court in that case was very, very suspicious around the side agreement and how it would be given effect And basically the court's view was it was the job of council to enforce council restoration, and any side agreement was going to be a bit of a difficulty. Side agreements can be upheld, but the council really drilled down on wanting, the court really drilled down on wanting council to be the one to enforce those outcomes. So we have these property law tools, and sometimes the Environment Court is a bit suspicious, sometimes not. A couple of other questions that came up from easements and covenants webinar I did a little while ago. So where a title has a right-of-way over a neighbour's land and the dominant land is using this right-of-way for access through this title from an adjacent lot, can the servient land legally stop that use since the right sits with the land, not the person? Very good question. I decided to draw a diagram. This is my survey diagram. So we have landowner A and landowner B, and there's a right-of-way over the black area which says that the owner of yellow can cross over that area in black to get to the yellow land. But even though that person also owns the blue land, no, they cannot use that right-of-way to access the blue lot at the back. They can cross over the black area to access yellow. That's what it provides. Even though they also own blue, they cannot legally use the black area to get over the red land, onto the yellow land, onto the blue land. A can restrict that because the right-of-way is only granted for a particular purpose in a particular way most of the time, and it won't extend to getting onto your own land and then going onto neighbouring land that you also own. Another question from last time with regards to a right-of-way. Are you saying that if the easement documents don't state the use of a gate is allowed, this would be an unreasonable impediment? So this was a case I was talking about, came out of Auckland a few years ago, where there's a right-of-way, a gate was put over this, and then part of the gate was removed, and that meant that the gate no longer achieved its purpose. Half a gate isn't usually much use at all. And what the court emphasised is a gate is about impeding access, a right-of-way is about allowing access, therefore there's no natural right to have a gate in place. If one of the owners doesn't like the gate, they can probably have that removed. In terms of a rural situation with stock, etc., well, while there's not usually any clear-cut answers in law, my answer would be, unless there's something particular in the right-of-way easement instrument, the gate to inhibit stock would still be able to be removed, even though there's value to it, even though it's important. The essence of a right-of-way is the right of passing and repassing, access and exit. It's not to impede that access in any way. There would probably be an ability to go to the court to seek modification of the easement terms on the basis that land use has changed or the expectations are with the gate in place that it should be upheld, but no real certainty about that. What it does emphasise is the importance of getting easement terms clear and accurate, not just relying on default terms and regulations, but actually thinking about what physical facilities are in place. As I said, a right-of-way is intended for access, and therefore a gate is not automatically permitted on a right-of-way and usually won't be permitted at all. That is all I wanted to cover. A little bit of a whirlwind through a whole range of issues, and obviously some of you will have heard me very rushed. Some of you will have heard parts of it twice. I'm now going to look at Slido and check out some of the questions there, and hopefully you can stick around for me to go through them. So I'll go into Slido. So, first question I've got coming up here, when does a jointly owned access lot need an incorporated society? Any number of owners in law? Okay, good question. The first part of that is no, there's not a legal requirement to have a resident society or incorporated society. Used to be a little bit complicated under the Securities Act, which is no longer in force because above 5 owners, any shared right would deem to fall under the Securities Act, and there'd be a whole level of compliance to worry about. The rules are a bit different under the Financial Markets Conduct Act, which is now in force, and they are more flexible. But I do have a rule of thumb here. I do think above 5 or definitely above 8, it gets very hard to manage interest between co-owners without some governance structure in place. if you have maintenance to pay for, it gets very difficult to deal with issues around capital improvements and raising money from people and enforcing debts and so on. So I do encourage it round about 7 or 8. You're getting into the territory of you'll need a governance structure like a resident society, but it's not a legal requirement. Also be aware at the moment the Incorporated Societies Act requires a minimum of 15 members, which can cause problems in smaller developments. Interestingly, a company is deemed to be 3 members, so you can have 5 companies. Sometimes you get over the 15 threshold by having 2 co-owners of a property, both being members. Sometimes junior staff and lawyers' officers are asked to be initial members, and that's a way of getting around that. Question around guidance on ways to have flexible staging and a resource consent. Yeah, a little bit hard to answer in the abstract, but a very good question. And it comes around to a bit of interplay with council around how specific they need you to be, and how general you can avoid, how general you can remain, because a little bit of looseness or vagueness can sometimes be useful when you're dealing with a resource consent. So if you say lots 1 to 5 will be in stage 1 and lots 6 to 12 will be in stage 2 and lots 13 to 20 will be in stage 3, that might be clear but not vague enough. Can we get back to wording along the lines of a reasonable proportion of lots will be in stage 1 and a reasonable proportion in stage 2, or 6 lots but not define them will be in stage 1, or a further clause saying that stage 1 may be divided into stage 1A and 1B for the purposes of council sign-off. So it's about having those tag words in there, I guess, that allow vagueness without too much specificity. Comment here, question here, unit title boundaries incur fire rating issues. Developers are telling us it's costly to fire rate a penthouse ceiling and are requesting the boundary to be under the external roof, which gives the top unit ownership of the entire cavity but no real use of it. Do you see this as a problem? I do see it as a bit of a problem on an ongoing basis, because I do a lot of unit title maintenance remedial issues 5 or 10 years after the plan deposits, and if you're going to have a top unit with ownership of the entire cavity but no real use of it, you're going to have to end up paying for that later on. So really what I'd ask is it's kind of okay to make those kind of decisions if you have to. The client does make the calls after all. But be as clear as you can on your survey plan, and ideally talk to the lawyer about putting even a covenant in place or something on the rules, or something on the title to record that this has been done partly not for the purpose of fire rating issues, but with the intention that this owner be responsible for this area and be responsible for paying for repair of this area. Because again, I've seen cases where they've debated at a judicial level why the survey plan was done a certain way. And if that can be clarified through something like a land covenant, that will save everyone a lot of time and energy later on. And that's one of the things I'm quite concerned about, being able to resolve these maintenance issues efficiently. Question, is there any issue with creating an easement over a jointly owned access lot when the part owners of the jointly owned access lot are effectively creating easements over their own land because they're both dominant and servient land, or burdened and benefited land? No, not really. Most easements that we create are done by the developer in favour of the developer, while the developer owns all the lots, so that works fine. And having those easements in place over the jointly owned access lot just provides that additional degree of clarity around easement terms and sometimes other services terms. Questions. So who was responsible for the fixture over the footpath? Council or the owner, looking at the Chang decision? Yes, very, very good question. Ultimately, the owners were, but not all of them. So if you can imagine that balcony being attached to level 2, the court ended up deciding that the owners on level 2 were jointly responsible for paying for repair of this particular balcony and dealing with it. Definitely ended up not being a council problem. even though there's some discussion about council's role, in fact Auckland Harbour Board's role and responsibility for that at an earlier stage. Question about my diagram, assuming that B is two separate titles. So let me go back to my ridiculous picture. Yes, and I should have labelled them B1 and B2. The yellow A is one title, sorry, the red area is one title, the yellow area is one title, the blue area is one separate title, and we have a right of way over A. But B owns both yellow title and blue title. So assuming that they're two separate titles, that's the one. Question, as urban policies change towards densification, is there a way of cancelling covenants to enable further subdivision, consistent with evolving district plan policies, rather than being bound in perpetuity by a covenant imposed by the developer on all owners restricting further subdivision? Oh, I wish there sort of was. Covenants are a massive problem in New Zealand. They are holding up densification, they are holding up affordability, they're holding up different types of dwelling typology and size. Number one question I'll ask a lot of people, do you need covenants? And people put them there because they think it puts up value. Maybe sometimes. I think in the long term it can put down value because you end up with a section that can't be easily redeveloped, and people are going to get more and more conscious of that, I believe. One of the best things you can do is tell everyone to put a time limit on the covenant, because really the covenant is a sales tool about improving amenity, and realistically the finite time frame of that is probably 10 to 15 years max, let alone 30. But 5 years on from a development, no one's usually that concerned about how it's supposed to be set up. Covenants could be tied to plan provisions, so if they have to be in place, they could be tied to plan reviews or ability to densify further. There is an ability to go to the court to seek modification of a covenant if it's no longer fit for purpose. But I talked about the Stonehill case in Pōkeno in the last webinar, and how the court in that case seemed to uphold the covenant restricting development essentially because it deemed that there was an intangible benefit still arising from it. So it'd be pretty hard to argue that when the developer has disappeared, but again in a residential subdivision, if you've got 30 or 100 owners, getting them to sign off on a change of covenant is going to be very difficult, and going to court is going to be very expensive. So surveyors, again, the onus is on you to get lawyers thinking about whether the covenant needs to last forever. And the short answer is it doesn't. It's just going to hold up further development, clog our titles, and destroy our land transfer system. That's strong. Okay. Regarding the Chan case and the veranda, how would rights responsibilities be recorded? Can't register interest in the legal road. Would use of a land covenant on the private title be the best option for maintenance and interface with the road controlling authority? Other thoughts? Yeah, land covenant would be a potential option. A covenant and gross sometimes, even, dare I say it, an encumbrance. Not a big fan of encumbrances, but if you put something on the title because it can't be recorded on a survey plan, that's a good option for a description of what is there. And it might be that there's a covenant on the title saying that there is this additional facility which cannot be shown on the survey plan if it can't, but which is attached to the building, which is outside the boundary, but which the parties agree that, consistent with the Chang decision, will be the responsibility of either the body corporate or a group of owners, and costs for that will be met by either body corporate or a group of owners, or both in some circumstances. And that type of arrangement is a good way to use a property law tool to record that kind of arrangement. Another question, I will wind up soon. Looking at your right-of-way diagram, if blue and yellow were one title with a right-of-way over red, and we subdivide into yellow and blue, should you consult with or get permission from the owners of red? No. The answer to that is no. If we imagine that yellow and blue are originally one title, they have a right-of-way over A, and that covers the whole of the yellow and blue, and then they want to subdivide. No, they don't necessarily need permission to do that. The right-of-way continues in place and extends to both yellow and blue. You're probably going to have to create a further right-of-way over yellow to get to blue to give that effect later on, but that's not going to be too hard. It is going to depend on the extent of the grant, the actual easement instrument, and how widely worded or not it is. I think that's all the current questions that are up for me. So on that basis, I will thank you all for your time and patience in having to restart today. And best of luck for level 2 and being able to enjoy restaurants, cafes, and so on. Enjoy. Thank you very much.
Thank you very much, Thomas. And once again, to all of our registrants on today's webinar, we do apologise for the glitch that we experienced. For those of you, I see there's still a few questions coming through on Slido. So if your question was not answered, I'm pretty sure Thomas would be happy for me to forward them on to you directly, Thomas, for a response.
Absolutely. Yep.
And also we will have a copy of this presentation available on our YouTube channel as well. So for those of you who would like to go back and re-listen to the presentation. So once again, thank you very much, and we look forward to seeing you sometime soon on one of our future webinars. Thanks, Thomas.
Right. Thanks, Jenny. Cheers, everyone. Bye.